Okay, so today we're going to discuss Connecticut paid leave. On the agenda today are what are the differences between FMLA and CTPL? What are the qualifying reasons for leave? What do you need to know about CTPL and FMLA and applying for those two programs and the additional resources, and then we'll have some time for questions. So what is FMLA and what is CTPL? Public service announcement, CTPL is not FMLA. So what is FMLA? FMLA stands for the Family and Medical Leave Act. There is a federal FMLA and a Connecticut FMLA. Both have been around since the 90s. Both laws allow eligible employees to take job-protected time away from work for certain family and medical reasons. The Family Medical Leave Act is implemented by employers and regulated by the state and federal departments of labor. FMLA does not provide income replacement. Employers may choose to adopt policies to provide for income replacement during the leave, but they are not required to. Employers may also continue to pay their employees their regular pay while they are out on parental leave, and employers may also choose to require or permit employees to use their earned accruals, which would be sick leave, vacation leave, or other PTO, while they are out on leave. The Connecticut FMLA changed significantly on January 1st of 2022. So to recap, FMLA provides job-protected leave for certain qualifying family and health reasons. So what is CTPL? CTPL stands for Connecticut Paid Leave. The Connecticut Paid Leave Act is a Connecticut law that creates a source of income replacement benefits for eligible employees who cannot work for the same reasons as FMLA. It does not provide job-protected leave. The Connecticut Paid Leave Act is implemented by the Connecticut Paid Leave Authority, a quasi-public agency of the state of Connecticut. So to recap, CTPL provides income replacement during certain qualifying family and health leaves. In order to have job protection and income replacement, an individual must apply for both FMLA and CT paid leave. This applies to most businesses with one or more workers in Connecticut. So CT medical leave provides job protection, does not provide income, and is eligible after 3 months of employment. Connecticut paid leave does not provide job protection, does provide income, and eligibility is based on a minimum earning requirement and employment status. So what are the qualifying reasons for leave and benefits? Well, there's medical leave for treatment of one's own serious health condition. This includes serving as an organ or bone marrow donor and pregnancy. There's also bonding leave to bond with a newborn's or a newly placed child, or for the time needed to process adoption or foster care placement. This would also apply to both parents, could be used anytime during the 12 months after the birth or placement, and also applies to birth, adoption, or foster care. There is also caregiver leave to provide physical or psychological care or comfort to a family member experiencing their own serious health condition. We also have military caregiver leave to care for a family member in the military who has experienced a serious injury or illness that occurred in the line of active duty in the armed forces. We also have qualifying exigency leave to engage in certain activities arising from the fact that a spouse, child, or parent on active duty has been notified of an impending call or order to active duty in the armed services. And lastly, we have the Family Violence Leave Act, which is very new. This is job protected time off, which can be taken by a worker who is a victim of family violence to seek medical or psychological care or counseling for physical or psychological injury or disability, to obtain services from a victim services organization, relocate due to such family violence, or participate in any civil or criminal proceedings related to or resulting from such family violence. And this is up to 12 days in a calendar year. So what is considered a serious health condition? A serious health condition requires both incapacity and treatment by a healthcare provider. Examples of this would be an overnight stay in a hospital, chronic condition for which you see a healthcare provider at least 2 times a year. A long-term condition for which treatment is no longer effective. This would be Alzheimer's or terminal cancer, or incapacitation during pregnancy, so prenatal appointments or complications during that pregnancy. And CT paid leave in COVID. Can a worker receive CT paid leave benefits if they have been exposed to or diagnosed with COVID? Well, simply being exposed to or diagnosed with COVID is not considered a serious health condition, but the worker may qualify for benefits if they meet the definition of a serious health condition, such as needing an overnight stay in a hospital or medical care facility, or being incapacitated for more than 3 consecutive days and requires the sick individual to receive ongoing medical treatment, or resulting in or worsening a chronic condition that requires treatment by a healthcare provider at least twice a year. So the primary difference between caregiver leave under federal FMLA versus the Connecticut law is a definition of family member. Under federal FMLA, an employee can take leave to care for a parent, spouse, or child who is under 18 or is over 18 and has a disability. Under the Connecticut laws, an employee can take leave and receive benefits for a parent, spouse, son or daughter of any age, a sibling, grandparent, grandchild, or an individual related to the employee by blood or affinity. So let's talk a little bit about that. What does related by affinity mean? That's any person with whom the worker has a significant personal bond that is like one of the family relationships listed in the statute, regardless of biological or legal relationship. This is a situation specific and depends upon the circumstances of the individuals involved. Examples of such relationships by affinity include, but are not limited to, an aunt or uncle who relies on the worker for unpaid care and has maintained a strong and enduring relationship with the worker, as typically seen between parents and their children or siblings, or an unmarried significant other of the employee with whom the worker maintains a familial spouse-like relationship despite their lack of legal relationship to each other. So what do you need to know about Connecticut paid leave? Am I covered by a Connecticut paid leave employer? Well, almost all employers who have 1 or more people working in Connecticut and the state of Connecticut as to non-unionized employees are covered employers. So who's not a covered employer? That would be the federal government, municipalities, of course, unless the unionized employees had collectively bargained to participate, local or regional boards of education, non-public elementary or secondary schools, railroads, governments of other states, and other sovereign nations. Other non-covered entities would be interstate truck drivers who work in Connecticut but live in another state and thus don't pay income tax in Connecticut, or spouses of active duty military members who have opted to continue to pay taxes in their home state instead of where they are currently deployed, which would be, in this particular situation, Connecticut. There are also other exceptions for sole proprietors and self-employed individuals. So this would be the individual must reside in Connecticut in order to participate. Coverage would begin on the first day of the first month following 3 full calendar months after the person enrolls with the authority. If they opt in, they must remain in the program for a minimum of 3 years. So sole proprietors and or self-employed individuals may choose to opt in to the CT paid leave program for themselves. So just to be clear, they do not have to, but if they opt in, they must remain in this program for a minimum of 3 years. They would need to contribute 0.5% of their self-employment income as defined by the IRS. And a sole proprietor who has employees may choose not to opt in for themselves, but they still must withhold and remit their workers' contributions. And just so you know, if you receive a W-2, you are considered an employee under the law, and you must participate in the CT paid leave program. This is true even if you are also the owner or officer of the company. So am I an eligible worker under CTPL? Workers earn at least $2,325 in the highest earning quarter of the first 4 of the 5 most recently completed quarters from 1 or more covered employers. So this could be full-time and part-time jobs, one full-time job, multiple part-time jobs, and is currently employed in Connecticut by a covered employer or was employed by a covered employer in the 12 weeks immediately preceding the claim for benefits. The CTPL authority, not the employer, makes the eligibility determination. So how long will you receive CTPL benefits? An eligible worker can receive up to 12 weeks of income replacement benefits in a 12-month period for all leave reasons, including military caregiver leave, except only 12 days of the 12 weeks can be used in connection with family violence leave. And an employee may receive an additional 2 weeks of CTPL benefits for a serious health condition resulting in incapacitation during pregnancy. So we're going to go over a little bit of the responsibilities. So CTPL contributions. The contributions for the worker's responsibility would be to contribute their 1/2 of 1%. And this is basically the FICA wages up to the Social Security contribution limit. The employer's role is to create the CTPL account, deduct the 1/2 of 1% of their employees' FICA wages, and remit those contributions to CTPL with the required backup information. For employers, if you have a payroll provider, ensure the payroll provider is withholding these contributions and remitting them to CTPL. And our responsibility is to receive and reconcile those contributions, process over and underpayments, and impose penalties for noncompliance. In regards to Connecticut paid leave claims, the worker's responsibility is to submit their application in a timely fashion through www.ctpaidleave.org or by calling AFLAC, provide supporting documentation, update their account with absence information and information about other sources of their income, and notify their employer about their Connecticut paid leave claim. The employer's responsibility is to complete and submit the employment verification form. Notify their worker about their PTO policies, including any short-term disability policies, and refrain from discriminating or retaliating against the worker for taking Connecticut paid leave. And our responsibility while working with AFLAC is to determine eligibility, review the supporting documents and approve and deny claims as appropriate, calculate and pay benefits, monitor ongoing claims, investigate potential fraud, impose penalties as appropriate, and the Connecticut Department of Labor hears appeals relating to denials of claims and to penalties. So what do you need to know about FMLA? Reminder, FMLA refers to the laws that provide eligible employees with the right to take job-protected leave for certain qualifying family and health reasons. And there is a federal FMLA and a Connecticut FMLA. So am I covered under FMLA? Well, to be covered under federal FMLA, this would be employers who have 50 or more employees within a 75-mile radius. This would apply to governmental entities of any size, including federal government, state agencies, towns, schools, railroads, and governments of other states. So are you covered under Connecticut FMLA? This would apply to almost all employers who have one or more people working in the state of Connecticut, and the state of Connecticut as to all state employees. So who's not covered under Connecticut FMLA? Well, that would be the federal government, municipalities, local or regional boards of education, non-public elementary or secondary schools, railroads, governments of other states, and other sovereign nations. So is my employee eligible for leave under FMLA? Well, to be eligible for federal FMLA, the employee has to be employed by the company for at least 12 months and had to have worked at least 1,250 hours in the last 12 months immediately preceding the leave. In Connecticut, they need to have been employed by the company for at least 3 months immediately preceding the leave, and there is a no hours worked requirement. Please note the employer makes these eligibility determinations. So what is the eligibility for job protected leave? Well, an employee can be eligible for federal FMLA leave only, Connecticut FMLA leave only, both federal and state FMLA running concurrently, neither federal nor state FMLA, but job protected leave as a reasonable accommodation, or no job protected leave at all. So how long is the job protected leave? Well, under federal FMLA, you can receive up to 12 weeks of leave in a 12-month period for all FMLA reasons, except up to 26 weeks of leave in a 12-month period for military caregiver leave. For Connecticut FMLA, you can receive up to 12 weeks of leave in a 12-month period for all FMLA reasons, except up to 26 weeks of leave in a 12-month period for military caregiver leave, and an employee may receive an additional 2 weeks of Connecticut paid leave benefits for a serious health condition resulting in incapacitation during pregnancy. This also applies to FMLA. You can receive those additional 2 weeks of FMLA for the serious health condition resulting in incapacitation during pregnancy. And then we have the Connecticut Family Violence Leave Act, which is up to 12 days in a calendar year. So responsibilities regarding FMLA claims. The worker is to notify their employer about a need to take time away from work in a timely fashion, submit their application as necessary, and provide their employer with supporting documentation, and comply with their employer's attendance and call-in policies. The employer's responsibility is to establish the leave policy, including rules about PTO usage, post the FMLA poster, process leave requests, monitor leave usage, and manage the worker's return to work, and of course, refrain from discriminating and retaliating against the worker for using FMLA. The Connecticut paid leave has no official responsibility relating to Connecticut or federal FMLA, but we do provide information as a part of our training because they should go hand in hand. The Connecticut Department of Labor regulates regarding FMLA and provides guidance to workers and employers about Connecticut FMLA. They also investigate complaints regarding denial of CTFMLA claims and discrimination and retaliation, as does the Federal Department of Labor. And all of these links are active, so you'll receive a copy of the deck. So how do you apply for CT paid leave benefits? Well, to start your claim for benefits, you can go to our online portal. Our applications can also be accepted via telephone. You will need to provide documentation to support your claim. Remember, you must notify your employer if you apply for CTPL benefits, and you will likely need job protected leave under FMLA, so you will need to apply to your employer directly for FMLA. What does the claims process look like? Well, this is a timeline from case creation to final decision. So the employee would start their application, submit their identity verification documents to AFLAC. The employer would return the employment verification form to AFLAC. And from the time window from the employee submitting their claim-specific forms to AFLAC, all forms have been returned. This is the point where everything that needs to be handed in is received. The case is considered complete and review process can begin. This is a 10 to 15 day period that has elapsed from date that all forms were received where AFLAC would issue a decision. So this is anywhere from 10 to 15 days. These are some helpful tools and resources that are available. All of these links are active and will take you right to downloadable PDFs. So we have an employee rights poster, an employee RAT card, employer toolkit, an HR toolkit, and a fact sheet. And for any questions you may have about the Connecticut Paid Leave Program, you can visit our website at ctpaidleave.org. We have a general information link. We have our contact us portal. For questions about your already filed Connecticut Paid Leave claim, log into your account through the CT Paid Leave portal or call AFLAC. For questions about CTFMLA, you can visit their new FMLA guidance at ct.gov. And for questions about federal FMLA, you can visit their website at the U.S. Department of Labor. Thank you. And just so you know, we've included in an appendix the FMLA process for any employers or small business owners, or that person that wears all the hats in the company that really just kind of wants to know what this process is supposed to look like. We did kind of include the flow here. And then just remember to tell your employees when you're approved for CT or federal FMLA, what the attendance and call-in policies and how they should be followed. If the employees need to notify their supervisors when they call in that they're taking FMLA, and there may be other laws that apply to their situation. And even if for some reason the employee doesn't want their leave to be designated as FMLA, in all circumstances, it's the employer's right and responsibility to designate time off that qualifies under FMLA as FMLA leave. And these are just some other laws to consider that may be available to the employee should FMLA not be an option. So I'm going to stop sharing my screen.